as somebody who suffered from this in the old regime, where I was removed from a plane and brought back that I could not travel, or my passport taken. Section 12 of the Constitution, which refers to Article 12, yeah, that a passport or a national identity card is not a privilege. It is a right. And that read together with the fact that, citizenship by birth, I think that is Article 16. No, 14. 16. A citizen by birth does not lose citizenship. And I've looked at the papers which the learned Ms. Ndimu has produced before the court. It shows that Mr. Miguna was born in Kisumu. His place of birth was Kisumu. And therefore, all that the Cabinet Secretary has done does not find favor with the law, but probably will address the court at another occasion on that very point. But if indeed Mr. Miguna was a Canadian citizen, again, what you can see from the documents which have been supplied by the prosecution is that even the Canadian High Commission was complaining about non-compliance with the law, not only the law of this country, but with the international conventions to which Kenya is a party. And therefore, my Lord, I would submit that the Inspector General, together with the Director of Criminal Investigations, should appear before you to explain, because this matter is no longer to deal with whether Mr. Miguna is here or not. But the more important question, have they complied with the orders of this court? And for that matter, my Lord, we'll still insist that the Inspector General and the Director of Criminal Investigations appear before your Lordship. And then, my Lord, there are also provisions which the Cabinet Secretary really should be familiar with. Who is a prohibited immigrant? You cannot be a prohibited immigrant if you're a citizen. The Constitution and the law does not contemplate a Kenyan by birth being declared a prohibited citizen. And the procedures for revocation of citizenship made spelled out clearly in the Constitution and in the law relating to the immigration. And in any case, as your Lordship pointed out the other day, the fair trial as a right is non-derogable. So Mr. Miguna must have been given, should have been given an opportunity on the basis of the allegations that were being made for him to put his case so the court could make a determination as to whether or not what the prosecution is saying is true or not, and whether those orders were indeed justifiable. But I just want to finish by saying, my Lord, these courts are the protector of citizens and their rights. Once we cannot find safety and protection from the courts, we are opening the state to anarchy, and accountability and respect of the law will lose its mandatory requirements. It is in the 16th century, I think, or 15th, when Louis the 14th said, "L'État, c'est moi, I am the state." Nobody can't be the state. The people of Kenya are the state, and all powers are delegated to various institutions of government. We can easily get there if the courts do not come in firmly and deal with errant public officers. So, my Lord, again, let the Inspector General appear before you. Let the Director of Criminal Investigations appear before you and give full account why they took the action that they took, delivering somebody who was a ward of the court. Mr. Miguna, throughout, was a ward of the court from Kajiado, and he should have been treated in the manner in which the court had directed. Thank you.
My Lord, the second counsel is Tula Kilonso Jr., Senator.
Yes, Thank you, my Lord. My Lord, the position taken by the prosecutor that at some point between the time they released Mr. Miguna Miguna, the applicant, he was taken by the immigration, is nothing but a falsehood. It's a lie. It quacks like a duck. It is a duck, and my Lord must find it to be a duck. Because, my Lord, you granted anticipatory bail. That means Miguna was under your custody until delivered to you. The circumstances under which Miguna ends up with the immigration, who are part of the police and part of government, is something, my Lord, must be tested by you. On the contempt, because, my Lord, after you granted the order and they violated, the contempt of court proceedings are alive until purged. Purged to the extent, my Lord, that there must be an explanation as to the reason why a court in Kajiado released Mr. Miguna Miguna, and at some point he ended up in a plane on his way to Amsterdam. The public prosecutor should be extremely embarrassed that he has given you a ticket using taxpayers' money that Miguna Miguna has been transported to some place because he's not a Kenyan citizen. That process, my Lord, is quasi-judicial. That process, at arriving at the conclusion of what they have given you today, that Mr. Miguna Miguna is not a Kenyan citizen, is a quasi-judicial proceeding. My Lord, before the contempt is purged, you must see that process. Who made that decision? When was it made? Who sat in that meeting? And where are the minutes? That's the law. But more importantly, my Lord, I'm glad that I'm appearing before you today because in 2008, a similar case like this one, Mr. Mohamed Sirat, who appeared before you as a petitioner, was deported by the Kenyan government in the middle of a petition. My Lord, you stopped that petition, determined that the deportation was an attempt to circumvent that petition. And my Lord, that gentleman ended up being an MP, sitting in Parliament. Kenyan government had declared him persona non grata. That case is not any different from what has happened to Miguna Miguna. And why is that so? Mr. Miguna Miguna, my Lord, was cleared to contest as a governor in Nairobi under Article 99. Mr. Miguna Miguna would not have been a voter if he was not a citizen. When did they realize he's not a citizen? All these things, my Lord, is part of the contempt, is part of finding a way to circumvent appearing before. My Lord, you should not allow that to happen. Before they come, stand there on oath and tell you, my lord, how they ended up circumventing your order. Because the process of deporting any person, whether it's a Kenyan or non-citizen, is also part of the Kenyan law, and that person must appear before the court. That is what the Constitution says. And therefore, my lord, if there's ever been a definition of travesty of justice, today and yesterday is where that definition fits squarely. If there's ever been a scurrilous abuse of court process, my lord, this is one instance. And if we cannot put an end to this, if we cannot dot the I's and cross the T's about violation of the principles under the fundamental rights, my lord, we might as well pack the Constitution of Kenya in a shelf and start using scrolls or something. But as long as, my lord, you're sitting here, take an oath to protect the Constitution, whether Miguna is in Amsterdam, whether Miguna is in Montreal, whether Miguna is under the sea, my lord, you can issue an order. That is our position. Because his fundamental rights have been violated, whether under the sea or anywhere else, my lord. So therefore, they must appear before you to show cause. And if they don't show cause, my lord, you can issue an order, my lord, for an explanation and to bring back Miguna Miguna back to the country. But before that, my lord, please summon them again to come before you. Thank you.
My Lord, I'll be very brief. My Lord, this is a clear case where the respondents are abusing not only their administrative power, but also judicial power. My Lord, I say this because this debacle commenced with a court order that was issued by the Chief Magistrate on the 1st of February 2018. It is on the basis of that order that the respondents proceeded to the house of Miguna Miguna, blew the entire gate, blew the entire front door, and seized him. Now, when this action was being undertaken, it was being undertaken on the suspicion by the police that Miguna Miguna was keeping weapons in his house, and he was also keeping documents that are
scrapped. They have chosen the easier way. They don't want to amend the Constitution, but they are scrapping the judiciary in terms of disobeying orders that are issued by the judiciary. More important orders made by the court. I join colleagues in saying the contempt has to be purged by all the officers you named and go at a later stage in probably different proceedings. We would like to see Mr. or Dr. Matiang'i has signed off as Fred Matiang'i, PhD, EGH, Cabinet Secretary. We will be dealing with him to show him that he doesn't even have power to sign the document he has signed, because in the government he's serving, he has not been sworn as a Cabinet Secretary for Interior. So he has no power that he's pretending to. If you look at the section he is citing, that was cited by my friend Dan Kanondimu, Section 33 deals with prohibited immigrants. There is a process to having a person declared as a prohibited immigrant. Section 43 gives the Cabinet Secretary power to make these orders upon recommendation from some authority or a tribunal. It can't be that they investigated yesterday on 6th, they took Miguna's papers to him, and then he signs. There is a tribunal that ought to have been the subject of some proceeding, which he will be telling us at that stage. So, my Lord, the illegalities that have been committed are undermining the authority of this court and telling us the rule of law means nothing except when you are in government. We must stop them in their tracks. I join Mr. Mbeta in saying bite really hard. Yesterday I suggested the same thing, that the representatives who came to court ought to have been detained until Mr. Boynet and Mr. Kinoti came to court. It is even shameful, my lord, that they would lie to you personally. Remember, before we adjourned after your ruling in the afternoon, you said you had been assured Mr. Miguna Miguna is in court and will be released. He was actually in court. He was not in court. You see, it is so shameful that they can taunt you in your face and say, we'll dangle Mr. Miguna here to assuage them, give them some palliative care, and then we can do what we want to do. I'm embarrassed that Mr. Ondimu, counsel whom I deeply respect, can take instructions of falsehoods and be sent here to present to be a messenger.
I think, my lord, I think my colleague, I have not, none of the senior colleagues here has gone into my person. All advocates here act on instructions. If those are my instructions, let him reply to my instructions. Not saying that he's embarrassed by him. I'm an advocate just like he is. I've worked with him in private sector and he knows where I work. So he can't purport to know what instructions I receive. So let him stick to his instructions.
Yes. Thank you.
Mr. Nubli, I know in your other life.
Yes.
So stick to your
my instructions, yes. I will buy him tea when we leave. But the point I'm making, perhaps if I refer to his clients, to provide false information, false instructions to counsel. When, as counsel, even on our side, we have sworn to defend the truth and defend the law and justice. It is also contemptuous of them to counsel, to give him lies, to present those lies to you. So they are in contempt of the lawyer, they are in contempt of the court, and they are in contempt of us on the other side as lawyers. They are in contempt of the applicant in terms of providing starkly false information to the court. But this long and short of what I'm saying, my lord, is the persons you named must come to court in person, purge their contempt. And part of the things they must do to purge their contempt is to present Mr. Miguna Miguna to you before in court in Nairobi, Milimani. Not to ask you to go to Ottawa or elsewhere to go and look at him. They must bring him here. If they purport to uphold the law, they must know that court orders are the law. Thank you very much.
My lord, I have a very brief reply. My lord, yesterday there were two orders that the court made. The first ruling which was delivered. The first ruling which was delivered was to the effect that there was no need for the DCI and the IG to appear before court.
That was good.
Yeah. The second order, the effect that the DCI director and Mr. Saidi do appear before court. So it is not true that the IG was required to appear pursuant to the second ruling. The people who were required to appear today was the DCI and Mr. Saidi, the officer in charge of flying school. As I have indicated, the predicament that is facing the DCI and where he is currently, it would have been impossible for him yesterday to make the arrangement because we all know what's going on in Boni Forest and the need to address that issue. My lord, you've been referred to by my senior colleague to the various orders that the Chief Magistrate's Court in Kajiado and here have made. My lord, if my colleagues have a problem with the search warrant and whether the returns have been made, the best forum would be at the Chief Magistrate Court to question whether the respective returns have been made and how that search warrant was executed. In regard to the orders that were made by the Kajiado Court, the Kajiado Court, yes, made certain orders. As to whether those orders have been obeyed, this, in my humble view, would not issues that you've been referred to the case of Mr. Siraj, I somehow handled part of the prosecution. The petition that he filed at High Court in regard to challenging the decision of the Immigration Department was actually dismissed. Mr. Siraj, through his advocate, my senior colleague, filed the notice of appeal.
The petition was allowed.
Hey.
No, not the election petition. There was another
The
petition.
petition was allowed by Justice George Lee. The petition was allowed. That's why I proceeded with the election petition.
There was such an
That is
order.
correct, my lord.
That is not correct. There is a notice of appeal that was filed by him. Why would he be filing a notice of appeal at the Court of Appeal? And he was granted stay orders against a criminal prosecution in Milimani Court.
It was a criminal prosecution, but the JR proceedings were heard by Justice Lee were allowed. And the decision of the Director of Immigration was quashed.
My Lord,
And I have that judgment.
Thank you for
I
the
also
assistance.
have two contrary judgments. My Lord, in that regard, I have two contrary judgments in that.
And it doesn't believe you.
It does.
You can adjourn this water and before and get those decisions.
Yes.
Yeah.
My Lord, I do have contrary decisions which I'll be relying on in my submission. I never thought this issue would arise, but I came prepared for such an issue to arise.
But we leave it. But it's the good of me.
Just proceed with your response. You know your response now. Those authorities will not cite it. Just respond.
The two decisions, they've questioned the basis under which the immigration made the deportation
You
order.
have said that issue will be addressed at another forum.
Correct.
You are supposed to address the issue of why the orders of this court were not complied.
My Lord, the orders of this court have not been disobeyed. It's a humble submission. No order. You've been told that you need to. The orders, one of the things is that the orders were complied with. The orders were directed to the DCI and OC Flying Squad to release Mr. Miguna Miguna. If another government department, which the DCI and Mr. Saidi do not control, take possession of this individual, you cannot blame Mr. Saidi and the DCI. The only application should be, what basis did the Immigration Department take up this individual? If this court issues an order for the Immigration Department to come and explain what was the basis for them taking up Mr. Miguna Miguna, would gladly then take up that matter and serve the Immigration Department on behalf of this court. But it's not the two individuals who had been directed to produce Mr. Miguna Miguna disobeyed the court. It is not that the two agents of the government have any disrespect, or anyone within the circle have any disrespect towards the court, towards the judiciary, and there is no need for this court to bite. We know courts can bite.
The question you asked is, was it produced before this court?
I have no knowledge. He was required to be produced. I never saw him. I heard in court.
He was not produced. He was not physically produced before this court. At what point did the Immigration Department assume his custody? From who?
The custody was assumed from the officers acting under Mr. Said. They were picked by immigration.
The custody was taken from officers under Mr. Said, who is under the DCI, who was acting under instruction of the DCI. Is that, let's talk so that I can hear you. Don't shake your head, I'm just saying for the record, just say the instructions were given by Mr. Said so that he handed over the custody of the applicant to the immigration officer without passing through this court's custody.
My Lord, the orders that court issued, the first ruling, the court said that, and even when the ruling was delivered at 3, the court said that either way Mr. Miguna should be released, not necessarily brought before this court. That's what I got the ruling to mean.
But did the court indicate that it was going to wait, even if it was late, to receive Mr. Miguna so that he can release it?
I was present in court, and I actually waited with court.
You waited until 7 o'clock with us. Mr. Odimu, you did wait with us up to 7 p.m.
And that's when I learned of all this, what was going on after I
and your
left.
instructions to court, your submissions which are on record, is that you have no instructions. You are saying that the people are not communicating with you.
Yeah, in fact, switched off their phones.
They had switched off, even Mr. Saidi had switched on his phone.
Switched off.
Off.
It's on record.
I remember what I said. But all this I learned after I had left court late at night.
Okay, I've heard you. You can conclude your submission.
My Lord, you've been asked to crucify the officer who had been sent by the DCI. The officer came and was sent by the DCI out of respect to this court, not to show that he disobeyed the court. This is merely a messenger. You do not crucify a messenger. You don't crucify a messenger. You don't bite a messenger. You receive the message and evaluate that message. That would be all. And there will be no need to bite anyone.
May I say something?
Maybe just one last point I forgot to mention in respect to the fact that the subject matter, the applicant is already out of jurisdiction, and whether court can make any subsequent orders. I wish to refer to the case of Zuhura Suleiman.
I'm not receiving any authorities.
Most of it.
You are supposed to have
No, it's because the issues I never thought they would respond. And since it's a legal issue that arose during reply, then I would only have cases to reply bigger than this issue.
That is incorrect, my lord, because he's the one who rose this issue, who brought this issue.
What's the name of the Director of Immigration? Kialangwa. Hmm?
Major General retired Gordon O. Halwana, that is KHALANGWA.
My Lord, I have a letter he wrote to me which gives his full name and title.
Okay, this is my ruling. From the submissions made, it is clear to this court that there is an obvious contempt of the orders of this court and a deliberate attempt by state agencies to subvert the rule of law in this country. Court orders once issued, must be obeyed. For the court to make an appropriate determination on what course of action to take, it hereby directs the second and third respondents in person to swear affidavits in regard to the circumstances under which the applicant and the interested party have a right, must be filed and served. The applicant and the interested party, that is the Law Society of Kenya, have a right to file affidavits in response to the affidavits that shall be filed. Further, the second respondent, Mr. George Kinoti, and the third respondent, Mr. Joseph Boynet, must further swear affidavits to show cause why they should not be punished in accordance with the Contempt of Court Act for disobeying the orders of this court. They shall be required to appear in person before this court on 14th February 2018 at 9 a.m. to show cause. These proceedings are adjourned to that date. It is so ordered.
Get the time so that
9 a.m.
before you take of the matter,
Yes.
I wish to request that you have a matter of court of appeal. I was requesting if you could come on 13th or 15th.
15th.